Well, hello, this is James Tanner, and I'm here again from the BYU Family History Library to talk about probate records and how to use the probate records in genealogical research. And I guess I'll need one couple of things of introduction. I've spent almost 41 years doing genealogical research, and a lot of that has involved research into probate cases. They're extremely helpful in finding families. And the second part of that is that I was a trial attorney in Arizona for 39 years and spent a lot of time in the probate courts. That was something that I consistently did over the time that I was an attorney. In the last few years, the last 15 years or so, I was in court fairly regularly with probate cases. So this is a topic that I understand, and hopefully I can help people get started in understanding this particular subject. So first of all, probate files go back thousands of years, and they certainly predate records of births and deaths. And that's the key here, is that the ability to find the birth date or the death date of an individual person, other than people who are extremely famous or have some reason to be noted in history. Those with that exception, most ordinary people kind of disappear off records beginning in the late 1700s. Usually by 1800, it's already difficult to find birth records. Marriage records are different. As a note, marriage records affect property rights, real property and personal property rights. And so marriage records are more common, and they may go back much further. But you may find that the only records that you can find are church records, and they may not be existent in the place where you're looking. And that's particularly true in doing research in the United States or in any of the countries that outside of Western Europe. So we're looking at something that's very valuable. Another factor that helps me understand the probate records is that my wife and I spent a year working with Family Search and digitizing records in the Maryland State Archives. And all of the records we digitized for a year were probate records. And all I can say about the process there, I just talked to emailed back and forth to one of the people who is involved in that project back in Maryland. That was a few years ago that we were there, and he estimated that they probably would take another 5 or 10 years to digitize all of the probate records in that one library, in that one archive for the state of Maryland. Another problem, of course, with probate records from the genealogical research standpoint is that very few of them are indexed. And in many cases, they're not even digitized. They're still sitting in courts across the country. One of the good news parts of that is that many of the courts across the country, even down to the county level, are digitizing their own records. And so they may have the records in the county available under a call. Each individual county probably has a different way of doing it. And so it's something that we're used to as genealogists in doing that kind of research. And I have to emphasize, if I have to say it a number of times, which I probably will, is that probate records are some of the most valuable genealogical resources for identifying whole families. It is, in a lot of cases, because of that lack of individual records and census records and things like that, civil registration records and others that are commonly used, is that the probate records are the only records that show complete families. And so this is the key here, is finding the probate record. And that can take a bit of work. I have one direct line ancestor that I have been looking since I began doing research. I have been looking for probate records and have yet to find his probate records. So it's a process that could go on for a while. To understand probate is a set of court or government procedures established for the orderly transfer of property from a deceased person to his or her heirs or assigns. Another point on this is that there are a lot of misconceptions out there about probate. And as I was talking before we got started here today, part of that problem has to do with people who are involved in what we call estate planning here in the United States. And a lot of the information that's put out in the general community about probate is just simply inaccurate and doesn't have really any factual basis. One of the things that comes up in genealogical research is that I've heard this many times that, oh, well, you can't find a probate because the women didn't own any property, and so therefore there's no probates for women. Well, usually if the woman survived the husband, then there was a probate for the woman's estate because whatever she inherited had to be probated. And then there was a question asked before the class started about the threshold level for a probate. And all I can say is that probate is mixed up with taxes and taxes on the property of an estate at the time of transfer were very popular and are still popular in a lot of countries. And so there's a time when everything in the estate, down to the last pin and saddle and cup and spoon, were taxed to some extent. And so the probates are, some of them, as you go back in time, you'll find probates are extremely detailed into as far as the property of the deceased. So these are things that happened because of taxation, and taxation's been with us, of course, since ancient times. So we're pretty well familiar with the process here. But what's happened lately, just as a kind of a side note, is that many of the smaller estates fall under exceptions through the taxation. The amount of property necessary for a probate to have a tax liability is very small. The other factor that creates a great interest, the amount of files of people that fall under the need to have a probate is a very small percentage of those are actually have any tax liabilities. Tax liabilities, for example, in the United States, the exemptions begin at about $1 million or higher. I failed to look up the exact number, and it changes practically every year. So if you're interested in seeing what the exemption amount is for an estate in the United States, then you can look that up online and see what the current exemption is. It's one thing that does change frequently. Most of the time that I was practicing law, which is about 10 years or so ago, the exemption level was up at around $3 million. So unless you had an estate larger than $3 million, you weren't paying taxes. But this is the reason why probate files are valuable for doing genealogical research, because first of all, they were imposed on everyone. Everyone had to have a probate, even if you had almost no property at all. The only people that didn't have a probate were people who did not have any property. Okay, so the reason why those records are valuable become very, very evident as you look at the probate set of records that go through a probate. It's not just one record, it is a bundle of records that extend over a period of time. A few years ago, I was looking for an example on a probate file, and I just living here in Utah Valley and Utah County or in Utah, I decided I'd just look and see where one of the representative probates here in Utah, how that went. I found a probate file that began in the mid to late 1800s, around 1860 or 1870, and lasted for 30 years. So there were not, people come to me when they start doing probate, and I say, "Well, did you look for a probate file?" And you said, "Yes, I looked at around the date of death, and I didn't find anything on a probate. There's no probate file." And I said, "Well, were you aware that a probate file could be filed years after the death? It may be possible that it could have been filed even 5, 10, 15 years after the person died or more." "Oh, does that mean I have to go look at all the records for all those years?" Yes, that's exactly what that means. And also, you find, "Well, I found the will and that's it." Well, if you found the will, then you probably have some access to the probate file. And as I just mentioned, those filings could have continued for decades, with hundreds of pages, with detail about the family down 2 and 3 generations. So, there's a lot of information here, and it's not ever wrapped up and handed to you in a package. You have to sometimes dig around and look through a lot of records before you find all the information that happens. The important part of this for a lot of people is that the probate file is the one that breaks down the brick wall. That's the one that actually identifies the family, puts the family in a very specific place and time, and verifies a death date or approximate death date of the deceased. And so the value of these is it's extremely extreme. There's just no question that you should be looking for probate records. And as I mentioned, if you didn't have any property, you didn't have a probate. So if your ancestors turn out to be as poor as most of my ancestors, looking for probates, if you find out that they live in the poorhouse or whatever, they had no property. Now, another factor, of course, is that the probates were necessary in order that people who owed debts didn't get a free ride just because they died. Their estate, meaning all the property they owned, was liable for the payment of all those debts. And so part of the process of a probate was to identify if there are any claims against the estate. And I could go on for hours with people talking about what's happened recently, meaning since around 1945 here in the United States, where they took an old English theory of property called a trust and turned it into what they called a tax planning or probate avoidance method. And so what people have today are trusts. My experience from a litigating standpoint, having been a trial attorney, is that we had just as much problem with trust as we had with a probate. And so it's not necessarily what you might think in the ways of how this works. And so what I'm trying to do here today is to establish a concept here that this is a very positive thing for genealogists. You should be happy that there was a probate. The people, the heirs, may not have been happy, but you need to be happy because that always creates records that are sometimes useful, sometimes not as useful as you would like, but a lot of times at least they establish some relationships and the time of the death of the deceased. One of the questions I'm always asking people is, did this person own any property that you're looking for? Did he own a farm? Did he or she own a farm? Or did they, whatever? And if the answer is yes, then we say, well, we're going to be looking for deeds and we're going to be looking for probate. And I would say from experience that most of the countries of the world have some type of probate procedure. Now, the only people that would not have a probate procedure would be countries that did not recognize personal property or did not recognize the ability of individuals to transfer property upon their death. So if that did not happen in whatever country, then there's probably no probate files. But if it did happen, then there are probate files of some kind. And as I mentioned, they go back into antiquity. In fact, some of the earliest records in Israel in Hebrew and Aramaic and the other languages are wills and probate files. So we really have something we can use as a bridge in a lot of cases. The important thing to understand is because of the changes in the law in most of the countries and in the larger countries, they've just learned that it's beyond the capabilities, and it ties up a great amount of court time and court effort to determine the value. And if you're in there determining the value of a pillowcase, or you're in there determining the value of an old chair, that kind of thing is basically what motivates the governments to say, okay, all we're really interested in is if you've got enough money. And so we're going to put that artificially high so that we don't have to deal with all this little stuff. And so when people worry about having a probate, they don't realize that commonly in the present age, even if you do nothing with your estate, it's very unlikely you're going to have a probate, unless there's a disagreement, unless there's debts, unless somebody is trying to collect money against the deceased. All of those factors may create a probate, which, by the way, are probably not going to be avoided by a trust. A probate file contains all the documents filed with the court. And so there's a way to open a probate by filing a copy of a will with the court. And then each time there's a whole set of procedures in the court about what happens after that. And there are records for each one of those procedures. So you are amassing a significant amount of documents, which, by the way, is directly related to the amount of property in the estate. Now, I'm not going to talk about anything past 1900 here in the United States. About 1970, actually, is when they had began passing what's called the Uniform Probate Code. And that kind of revised all of this stuff. But back in history, what we're dealing with as genealogists, these records are extremely valuable, as I will say over and over again. So a probate case file can have hundreds of pages of documents, and as I mentioned, last more than 30 years. And I know that they can last more than 30 years because I found cases that have lasted more than 30 years. So it's not unusual, and time can go on forever. And you cannot predict the kinds of documents that might have been filed in a probate action. The questions that are raised, the issues that are involved in the resolution of the debts and the disposition of the property, like the real property and the personal property, you just cannot imagine the amount of information that is going to be created here. Okay, so it's kind of like opening up sort of a new world. You get into the probate records, you find out information that perhaps you had no idea existed. So what are the kinds of things that you might find? You would find wills. Wills are documents created before death by someone basically asking that the property be distributed in a certain way to certain of their heirs. The idea of a court is that they will play along with that and distribute the property unless there's some conflict or challenge to the will. That's where I came in primarily. As a litigator, I would be walking into court because somebody was unhappy. There are bonds, which means that you have to have the people who administer the estate, and they have a lot of different names that we'll talk about, but the people who administer the estate had to post bonds. So these are other people. They could be relatives. They could be, one of the things you may find is the wife's a maiden name because the person who got the bond was one of someone in her family. Petitions are requests that go to the court. They can be endless, asking the court to do certain things, sell the property, dispose of the property, cut someone off, take, anything that comes up in the proceeding. Accountings are always required, which means that you have to do an inventory of the property. Over the years, as you go further back in time, particularly in English-speaking countries, the information that is required becomes extremely specific. And so, as I mentioned, you may be looking at a list of every piece of dishware and every item of clothing and every other thing that happened or was owned by the deceased. Today, the accountings and the inventories putting a value on the property, and then there's a sale, usually a sale in the probate of the property in order to satisfy creditors and to distribute the proceeds of the sale to the heirs, unless the deceased has specifically designated that an item of personal property goes to a specific individual. There are orders by the court telling people when to show up and what to do and and what the court wants to look at. Then there are decrees that determine where the property goes at the end of the probate. And so somewhere down the line, there's going to be a decree. The simple way to look at this is, let's suppose that the person owned a farm and that farm was valued at X dollars, let's say $1,000. Well, then the court would impose a bond to protect the value of that property. Then there would be petitions back and forth about the property or the sale of the property. They would have to get someone to give a valuation on the property. And then there would be a legal description created. The deeds would be looked at to make sure the property was actually owned by the deceased. And then just as if it were going to be sold. And then there were orders ordering the property to be put up for sale, and usually then at an auction they would sell the property, and there would be a final decree having the administrator of the estate to sign a deed and to turn it over out of the property, and they would have what was called a deed of distribution, which would then take the property, the farm, out of the estate, and then the heirs would divide up the proceeds. So there's a lot of value, and here's some of the values of a probate file for research. First of all, it helps to identify family members. The wills and all the probate proceedings often tell who the people are and how they're related, and may tell the grandchildren's names. It may have all sorts of information in the will. And yes, if you go back far enough in time, you'll have a problem like with this screenshot, finding out that all these records are in handwriting, and you're going to have to learn how to read the handwriting. The main issue, of course, for the genealogists who don't happen to be attorneys is that, and even if you're an attorney and you haven't ever done probates, the same problem, and that is that the language may be totally unfamiliar, and you may have to work through and find what all these things mean. It may give the wife's maiden name, which is a bonus. Establish the relative's economic status. When you see the inventory of the property and the appraisement, meaning the value of the property, then you begin to immediately see what happened with the property. One example, which came up during the time that my wife and I were digitizing probate records in Maryland, was, of course, Maryland was a slave state, and the enslaved people were listed as part of the property of the estate. And so when people say that there aren't any records for the African Americans back beyond 1860, they simply do not know that there are records, which primarily end up being probate records. And it may reveal unknown family relationships. You may find out who is related to who, and that may be a surprise. And also may be the only record of the ancestor's death. It's not unusual that you can't find any other evidence of the ancestor's death. You might, because you found a probate record, then be able to find a cemetery record or a cemetery marker with some information. But sometimes it's easier to find the cemetery marker and then begin looking for a probate record where the cemetery marker is located. And in the United States, the probate records originate and are maintained at the county level. So all the counties across the country have procedures for probates and have a court that's designated as the probate court. And they have different names across the country. And then those records are, if they're available, are usually maintained on the county basis. Now, if the records have been in the county for a long time, or if the county split and records have moved, then you have the same problems you have with all records that are kept at a lower level of jurisdictional level, and that is that they may not be readily available because they've moved to some other county or the original county or in different situations, and that may take some historical research. And I might mention that there are 3,143 counties and county equivalents in the United States, so we have that many different ways of handling probates. And I mentioned just a few minutes ago about beginning in the 1970s, we had a movement to have uniform probate laws. Well, they weren't that popular, and there's only a few, not a large number of percentage, but only a smaller percentage of the states that have actually adopted that. Sometimes they adopt parts of it, and you still can count on the fact that the probate law is going to be different in every state, and the procedures may be different in the counties. And the important thing to understand is that probate records are kept with all the other county records. And it will depend on what you particularly are looking for. You may find that you're looking through a lot of records in a county, the county records, and finding probate records sort of scattered in. So there's what happens in different counties is that some counties keep all their probate records in one file. So the probate started and everything that happens with that particular probate goes into one file. And some did not do that. They just took the probate records and put them in what's called the docket, into the file of the records that are in the court in the chronological order that they came in. So you may have to search through a lot of records, and depending on how the records have been segregated out. And you'll see, for instance, from this slide and the screenshot here for Grayson County, Texas, that to search the probate records, they begin in 1983, which may not help you a whole lot. And request form for probate records go back to 1846. The question there would be, when was this county created? And are those perhaps the oldest records that exist in that particular county? So that's a kind of a blow up of that, what I was looking at just a second ago. So you can see that this will tell you rather quickly if those records had even been created in this particular county. It may have been part of another county before 1846, and that's something else you should know about. And I'm going to have to emphasize this, that probate laws differ from state to state. So it's important that you identify the place where the probate records are archived, meaning where are they kept? They may even be in a state archives. That's why we were looking at probate records at the Maryland State Archives, because the older probate records had all been transferred to the state archives. And so they were all sitting in Annapolis, Maryland. But not all, but the bulk of the records, not the current records that were being probated. But here what we have are sort of a searching from state to state. Now, all the states and all the counties that I'm aware of in the United States today are online. And it's pretty simple to determine how many counties and the names of the counties of every state in the United States. And once you have identified, to some extent, this whole process is initiated by the genealogical researcher identifying events in the exact location of events in the ancestor's life. And the one that we're most interested in is the death of the deceased, of the person, and we want to know where that occurred. Why? Because the probate file can be filed, the probate can be filed in the court that has jurisdiction over the place where the person died. Or it may have been filed, there may be even more than one probate for one person, by the way. There's what's called ancillary probates. The properties may be in other locations, and there may be additional probate files that had, or probate actions that had to be filed in each state where property was located. So if you get in a situation where you're working with someone that had a lot of property, they may have had a beach house in California, they may have had a ranch in Wyoming, they may have had a house in Utah, they may have been winter residents in Arizona and had a house in Arizona, and then they had a house in Florida, and they had a house in Michigan because that's where their family came from, and so forth. And yes, I have traced and worked through situations just exactly like that with probate actions that were spread across the country. And yes, we had to hire attorneys in all of the different states to handle the property that was in that particular state. And we also had to come to an agreement as to where the primary probate action would be established. So you're thinking about this as it goes across, as the population of the United States spread from east to west across the country, you may have a difficulty finding all of the probate actions. They're out in separate counties. I would suggest checking the local laws about probate before doing some research. I don't mean the law today, I mean the law back at the time. Find out if what the actual law was. Doing research, historical research into what laws existed in the United States and in England and other places where you might be working, as well as in other countries in Europe, is just basic historical research and finding out what the law was back at a certain time, and the jurisdictions at a certain time are both things that depend on the prowess of the person who is doing the historical research. And I would always encourage searching online for the records long before you started getting in a car or taking a plane flight someplace to look for records in the county directly. You may find that the records, when you get to the place where you're looking, that the records have been digitized and that they are no longer stored online and no longer available, and that the only way you're going to get access is through their online resources. Then you can contact the court. Whenever I get into one of these situations where people are doing research and they say, well, I don't know, how do I get started with this? And the answer is, call the court. If you know where the person died, or you know approximately, and you know the county, then you can call the county and ask them where their probate records are. And they'll say, well, they're all online, or they're all kept at the courthouse, or they're all sitting up in the state archives, or they're in a historical society. In other words, these people are going to get this question. All the court people in various counties across the country and around the world are going to get these questions regularly, and they will, if they don't avoid answering, you may very well find out that information. Another way, a good way to get into this, is the Family Search Research Wiki. It's on familysearch.org under the search tab, and it's called the Research Wiki. And it's obviously in other languages also. And if you look under probate records, it will tell you for the time periods involved where those probate records are likely located. So that is the answer to the question. You go to the Family Search Research Wiki as a start, and you look it up, and then you can start calling to see what the availability is of the records. Now, don't be surprised if the counties have monetized this process and will start charging you for copies, or start charging you for physical access to the records, and may even charge for online access to the records. So there may be some kind of registration process and a cost involved. Some U.S. probate records are digitized on Family Search and on Ancestry. There is a category of archived records. While we were digitizing records in Annapolis, Maryland, Family Search asked if we would go up to a conference of the county clerks in Pennsylvania, which we did, and we spent a couple of days up there in Pennsylvania talking to county clerks, and some of them had their records digitized, some of them did not have the records digitized and were interested in having Family Search digitize the records, and some of them didn't know what digitizing was and weren't interested. So it's kind of a spread of what's still going on constantly throughout the world as far as preserving and making available records. And Ancestry has indexed some of the probate records in the United States and Great Britain. So you may find probate records on Ancestry.com. Always check the catalog of the available records to see if they're probate records before you start trying to do searches and things like that. It's probably a really good idea to look at the catalog on Ancestry. It's called the card catalog, the collection catalog on MyHeritage, and the catalog on Family Search, and the list of all the records available on Find My Past and so forth. Each one of those big websites has that kind of a record. Having gone through the process of learning all of this from law when I began law school, you can find, it may very well seem that when you start reading a probate record that it sounds like it's in a foreign language. And the writing may look like it is in a foreign language, and it may be in a foreign language. As you go back far enough, you will find in Europe a lot of the probate files in Latin. So you may just find that kind of information. Now, here's the key to the legal part of it. The Black's Law Dictionary, and this is good for all kind of English derivative, when I say English language and Latin derivative countries, because different legal terms are all going to be in this Black's Law Dictionary. Every attorney that I knew had a copy of Black's Law Dictionary someplace close at hand. Now that we have that online and it's available online and it's free online, I don't think that at least some of the attorneys probably do not have a physical copy, but basically it was the go-to place for finding out some legal term that you weren't familiar with. And you can access it if you do a search for Black's Law Dictionary, you'll find multiple copies of multiple different versions and revisions of the law. You do not need the most current. There's no reason to even bother about worrying about the latter half of the 20th century, and say from 1950 up to the present. The language is going to be modernized to some extent in probates, but it's also not going to have nearly as many terms that you don't understand. So what is an estate? We keep using the term estate. I keep saying the estate. And what the estate is first of all, as I mentioned, the country's laws must recognize individual property rights. It's what individuals have an interest in property. And the individuals must have the right to alienate, that means to sell, rent, do whatever, or transfer property to a spouse or others after their death. So if those two things aren't satisfied, then there's not going to be any probate laws. It's just not going to exist. Probate is a process of doing this. And if you can't do it, then obviously you don't need a probate. And the concept here is that everything owned by the deceased at the time of the estate is in the estate. Now, when is it not in the estate? That's always a question that comes up. And that depends on the law. So once again, if the law in the jurisdiction you're looking at, if it happens to be Arizona or Utah or someplace like that, then there's going to be a threshold that says, oh, we don't consider household items in bulk to be part of an estate. So how do they transferred? They're transferred by people coming there and having garage sales or estate sales, or having their relatives come in and choose what they want, and nobody cares, and nobody's going to get taxed on it, and nobody has any problem with it. But as you go back in time, like I've mentioned, to emphasize that, the amount of that property that is exempt begins to disappear. And depending on the state and on the county, it could disappear somewhere in the mid 1800s, or even more currently, like the early 1900s or wherever. So it may be that probates are more and more, like the reason why, this is the reason why probates are more and more common as you go back in time. So the will is a document created by the person before death that attempts to influence the distribution of the person's property after death. Now, that statement I make in there is, I won't call it an editorial comment, but I would call it a experience comment. People think that everything has to go by the will. Well, unfortunately, that's not true. The will is merely as I say here, an attempt to influence the distribution. And if the distribution does not, if the people who are the heirs, the people who are going to receive the property, don't agree, then that will may not have very much usefulness. It may only be a suggestion, and it may not be the way that the property ever gets distributed. So what are the requirements for a will? And that depends, again, on the local law, but generally speaking, they're all about the same. And they must conform to the legal restrictions in force at the time the will is made. So whether there is a will or not is defined by the law at the time that the will was actually made. And there can be all kinds of different wills. And usually they must be in writing and witnessed, or must be in the handwriting of the deceased. This is called a holographic will, or maybe oral if it's witnessed and written down at the time or shortly thereafter. So those are the kind of things that you look for as to whether or not a will is valid. The big transfer here was people who would come into a law firm, and even our law firm, on a regular basis, and they would say, I need to change my will. And we'd say, well, what happened with that? They said, well, Fred didn't come in and he didn't make his payment on time, or Fred didn't call me on the phone, or Fred didn't notify me, and so I'm cutting him out of my will. And that would be that week, and then he would be put back in the next week. And so if we would always urge the people to destroy all earlier copies of the will, but that didn't always work. And that's one of the reasons we end up in court. We had 15 copies of the will, and we didn't know which one was the last one, or which one really was the one that was intended to be binding. So basically, a will depends on the law of the jurisdiction, the place where the will is made, the county, the state. It must refer to or list the assets. So the will can't just say, I want to give everything away. It actually has to say what it is you want to give away, or it's going to be very difficult for anybody to not disagree about it. It has to identify who's going to benefit from the will, the beneficiaries, the people who receive it. And it must name someone who is to be the executor or personal representative of the estate. That means the person who administers, also called an administrator, must be signed and witnessed. And that was it. So there are two kinds of things that occur. Probate may be necessary. If there's a will, it's called a testate. The proceedings are intestate, are the testate of a will. That means the will is being determined how it's going to transfer the property. If there's no will, then we have an action intestate, which means without a will, If that's the case, then you look to the law of the state, because the state's law may determine how the property is to be distributed and who gets the property if there's no will. So unless you want to disagree with what the state does, if you do disagree with what the state has for their way of distributing the property, you absolutely will need a will to distribute it different than it will go with the state. And that depends on each state and each county, and you need to know what that is. If you want to look that up, you look for something what's called intestate succession. So if you typed that in for Arizona, it would tell you and show you the law that happened, how the law was applied if there was no will. So here are a couple of definitions. A testator, testatrix, that's the person that makes the will. An administrator is the person administering the estate without a will. An executor or an executrix, female version. Those have been discontinued long ago, but they're still around in history, so you have to know about them. Is the person administrating the estate if there is a will. And a personal representative is anyone administering an estate, and that's under the Uniform Probate Code. So we did away with the male-female designations, and it was interesting because when I was in law school, one of my trust and estates probate classes were being taught by the person who wrote the Uniform Probate Code for across the country. So that was kind of an interesting thing that we were involved in. So don't ignore this valuable set of records. These records are tremendously valuable and helpful. They're just hard to find. I just like to mention we have 14 videos on the BYU Family History Library YouTube channel about probate. So if you want to get into it in more detail, I did a 6-part probate series that goes into a lot more detail about how probate works and gets more into the technical parts of the probate. So your learning process never ends. In other words, once you start the process of doing research and genealogical research about your family, you're going to find out that there's always something you need to learn. It just happens that way. That's the way it's structured. It's historical things. And as you go back in history, the language changes, the laws change, the customs change. And without learning all that information, research going back becomes very difficult. It's difficult anyway, but it becomes nearly impossible unless you go through the learning process. So that's kind of encouraging everyone to take the time to do some learning beyond the basic introductions. Okay, well, thanks for watching. Let's see if there are any questions here.
There's 2 questions from Sandra in the Q&A.
I'll say, what can I infer from an 1844 Galatian County widow's probate that doesn't mention any family? It's only 7 or 8 pages and mostly things being sold to people with surnames that are unfamiliar, not found the will. I'm trying to prove or disprove the connection of my family of the same common surname, Gates, Brickwall, etc. Okay, well, the answer to that is those documents are probably not fully explored. There may be a lot more documents out there. And I would keep looking at the court file and keep asking those questions. If you're looking online and that's the only thing you're finding, that does not mean that they digitized the entire probate file. They may have only digitized a few documents and that was it, because that's what they had at that time. So I would be talking to the county, and I would be talking to a county historical society and a county genealogical society, and I would be questioning the court by telephone, asking if where there might be more records. That's kind of the solution. It's just a matter of getting more records. That doesn't sound like the whole probate file. And maybe she had no identifiable heirs or family members, and so there was nothing they could do except sell off the property to people who were willing to pay for it. When you say
Yeah.
property, no probate, are you referring to land as opposed to personal property? The answer is both. When I say property, I mean property, real property, which is land, and personal property. If there's no probate, you can't have land. If you have land, you automatically have a probate going back in time. Even if you have very little personal property. But what we're talking about is anything identifiable as part of the estate, meaning everything owned by the deceased when they died.
We have a question in the chat there from Robert.
Are wills probate records considered public records? Yes. The answer is definitely yes. They're all public records. I have to say yes, because I can think right off my hand, I can't think of an exception why they would not be. There's no privacy. Dead people don't have privacy. But it's helpful too, because the people that are still alive are usually named.